finish up.
So still in Ways and Means, still Thursday, May 8th. 10 to 11. We have a few minutes here. Sorry, I just got lost in the agenda for a second. I would love if we could talk for a minute about if we are going to place a limit, how we ensure regional equity of resources. Folks are interested in a per county cap. If folks want to just put prioritization criteria in VEPC's hands via rulemaking. If regions without grand list growth should have more resources, or if regions that naturally have more need for growth, I don't know, whatever it is. Ideas. Representative Odie.
It's not my last idea. I just want to say, well, what worries me about CAP is then we are starting, and it's rulemaking or anything else, then we're going to try to anticipate, we're going to try to put some kind of thing in our heads that kind of could not give us housing where we've got dramatic need. And then that might prevent housing where we also have need in smaller towns where there might not be that much employment, but where we want growth also to happen of housing. I just don't know how we're going to, if you make it scarce, force scarcity on this. Why would we want to force scarcity on this? I just don't get it. I don't get it.
Because I think if people's property tax bills are too high, there's scarcity in people's households. Representative Holcomb, you are next up.
I was actually gonna ask you a question. One of the things I'm really struggling with just generally the whole session is I'm unclear on what our theory of action is about how we're building future prosperity. And so I was gonna say, as people make a recommendation, maybe you could say your assumption. And so we can look at what you're recommending in the context of your assumption about how it makes things better. Because, in answer to yours, like right now, I'm aware I represent two communities that are heavily subsidizing other towns, and they should because they have more prosperity. But if we undermine their ability to do that, it actually hurts everybody. So I think we've got a lot of zero-sum thinking here, and we have to be asking about how do we maximize opportunity for everybody. And it may not be that we give everybody the same thing. It may be that we target areas for growth. And we understand as we do so that those areas of growth are actually going to be part of lifting everybody up. I don't know what that looks like, but I think we ought to be at least saying what we're assuming so that we can evaluate the recommendations in context of assumptions, because a lot of what we're doing is pretty inconsistent.
Yeah, along that line, I was intrigued by the chart one of our people did yesterday showing the counties and how much would be allocated to each county. But the thing I didn't like is it looked to me like they were absolutely upside down, because the counties that lack growth should be the counties that were giving more ability to institute CHIP and TIP, by the way, but especially CHIP. So I think if we could find a way to turn that upside down, and then that's going to help everybody by funneling our resources into the most needy areas. So I'm thinking Essex County, Northern Franklin County, Lamoille, parts of Lamoille. Anyway, so forth.
And so you're recommending sort of the inverse of what I put on the table yesterday, rather than sort of a statewide cap with a prioritization criteria.
Yes.
Okay.
Yeah, that's what I just said.
Okay. Yes. Yeah. Okay. Representative Wazazak and then Feltus.
I have a different take. I don't like the county caps. I think that we should have I think we should have a statewide cap. I think the 1% makes sense. I think that also going back to Representative Feltus's early point of all of the existing tips right now are only at, 6 to 7 million theoretical expense from the ed fund. So a $13.9 million cap annually seems both very generous and a reasonable protection of exposure to the education fund. And I worry about doing county by county caps, not just because, but one of the reasons that concerns me is just like the patterns of development could be that if we have the opportunity to do a really great housing development in Windsor County, but 10 years ago, they hit their cap. I don't want to have to say no to that development. And I think that we also, but I do agree with you completely about the goal. One of the assumptions I'm making about this program is that we're trying to incentivize development in areas where it's harder to do that. And, I think the rural communities, which is why I would favor, if we had a map for tier two, putting tier two in. But I think that that's the goal, is trying to get more development, but doing that via a county cap does concern me.
Would be a town.
No,
No, it
he
would,
said no county cap, yes cap. Representative Felker.
yes.
I would like to see a cap. I was thinking county cap would be fine, and to Representative Brannigan's comment that it's upside down, I think it's just a reflection of the population of the area. And I'm sure Chittenden County needs more housing. They've got more people, and we need housing where I am too, but the total population of that is not the same. So we don't need as much. We need it, but not as much as Chittenden does, because they got more people. And I wonder if there is a way to tie that to some assessment, there must be, of lack of housing. Is it greater in in relationship to the population? For instance, is there a greater lack of housing in Caledonia County in relationship to its population? Is the demand higher there than it is someplace else? I don't know if you can do that, and if you can't, I would just go by the county. But I would also remind us that this program is only going to be in existence for 5 years, the way it's set up here, in terms of starting projects within 5 years. So I don't think we're going to run into a huge amount of development that way. I mean, I hope we have some development, but I'm not thinking that this program is going to be available for all of 10 years, or at least for now, it's only 5 years. And yes, a future legislature can extend it if it seems to be suitable.
And I'm imagining a future legislature would, but who knows what 5 years will bring.
But at that point, they can relook at the caps or the dollar amount or whatever.
Okay, so I heard you saying yes cap and a county cap is okay.
A county cap is okay unless we can somehow tie it to a housing demand.
And we could ask VEPC to do that, or ask the chipboard that we're all many of us are uncomfortable with, but could maybe get better than it is to do that, maybe. I don't know, that's an idea. Okay. I think Representative Holcomb was next, and then Russell.
Yeah, I mean, when I think of new housing, I'm also thinking of new income tax. And again, any prosperity we bring to the state, we're bringing to all communities. I like what you're talking about targeting. I'm looking at rental vacancy rates. It's pretty clear there's significant variability around vacancy rates. And to me, the places with the highest vacancy rates are the places with the highest demand right now that, the lowest, inversely. So I mean, that could be a way to target. If we have communities with a 0% vacancy rate, clearly there is demand for housing in those locations. We've got places here that have 14% vacancy rate. That's probably not where people are trying to move right now. And my concern is we can't buck larger economic trends. We can try to harness trends in ways that create more opportunity for everybody. But if we've been seeing larger economic trends, this tiny little program is not going to change it. Just saying.
So I hear vacancy rates as sort of a new idea on the table. Community by community vacancy rates probably won't work because the numbers aren't clean enough, but it could be regional vacancy rates or something. Okay, Representative Maslin.
Same. I think cap is absolutely necessary. And I was looking for metrics on how to prioritize this, and I think vacancy rates is a good place to start. In the regions, maybe it could be RPCs or something like that. They're kind of probably too big and too loose, but maybe it's by community. But anyway, vacancy rates is a good metric, and I'm very much in favor of that. And I would also back up a little bit to say where this money, what are we going to solve for? Right, for bringing down the education tax, property tax, and I think from the district that Rebecca and I live in, I think solving for reducing property tax, which means growing the grants, is where I need to start.
So there's vacancy rates and then also stagnant grand list growth is something that's been used in other
Good.
places of policy lately. I think sometimes it's flipped on its head a little bit, but that might be a useful one. Yeah.
I also don't want to be like so prescriptive
Yeah.
that this tool becomes unusable. So I think that these things we're talking about would be really good to incorporate into a prioritization process. But I would be
Yes.
hesitant to say, you know, you can't do this if you have X vacancy rate, because that could also change from year to year. If it's right, exactly, right. So
Yep. And the
not opposed to the concept. but-
and the prioritization would be part of rulemaking.
Right, right.
Yes, Representative Holcomb.
Yeah.
I just want to 100% that, and that's why I think that's why I was supportive of the idea of a chip board that might be reconfigured with housing expertise, because we don't actually have that here. But it also, I don't think you can look at anything at Vermont without looking at level of poverty as well, to make sure that that isn't the reason things are happening.
Totally.
Representative Higley. And then we are pivoting to Green Mountain Care Board.
Hold.
No, go for it.
Again, this may be a little bit different, 1% cap yearly, correct, would be 14 million,
Mhm.
double what the TIFs do now. But, and this isn't really my idea, but I heard about it, talked about, not having a cap at all at first, just to see what kind of influx there is for the program, and then work into the bill that, through one of those, I call it, that's what we think it's.
That's
It is, that's the,
Pepsi.
Pepsi would, see that whether or not there needs to be an adjustment or whatever. And again, somebody else also said maybe in 1 year, 1%, I don't know, wouldn't be enough for have an adjustment based on what's out there and what's actually needed and going forward. I don't know. That's just an idea as far as not having an initial cap, but looking at a cap down the road. And again, just to go further, some of what maybe Representative Maslin was talking about, but hopefully with what we're doing with the foundation formula, in 5 years, I would hope we're going to somehow stabilize our education spend. So again, we have this growth, then we're not going to have such a huge growth in the tax rate, I would hope. That's my hope.
Also my hope. Thank you. Representative Maslin, we are pivoting to a new topic and then we will come back to this. So I'm going to take a brief moment for a changing of the guard.
I'm not being.
And Jen, if you want to settle in. Thank you.
Something like that to kind of.
We're sticking into our snacks.
That's fine.
Temporary. It's not so permanent as something. We've heard that.
Thank you, Mike.
No, smart idea. There's no one in the bed, it's not your fault. Okay, here we are.
Hi, Jen.
Hi.
Thanks for joining us. We're gonna do a real, I think that was a good deep breath for us as we totally shift our brain space to you and what you're sharing with us. And folks, this is like a very new topic for us. I have scheduled 20 minutes for it, and we're gonna see how it goes. I think our jurisdiction is fairly narrow, so thank you. Jen.
Sure. Good morning, Jen Kirby from the Office of Legislative Counsel. Do you want to be looking at the
Yeah, that would be-
bill?
Whatever you think would be the best way to help us understand what we're doing here.
Okay, probably, so we'll start with the bill as passed by the Senate, because actually there are just 2 instances of amendment from House Healthcare, and they don't really affect your work here. That may be a little bit on timing. I will put this up on the screen. This is first 19. So this is S63. This is an act relating to modifying the regulatory duties of the Green Mountain Care Board. And sort of at a high level, this is reducing a number of the duties that the board has or reducing the scope of them. There's also a change to the bill back formula. So that's part of why the bill is in here. There's bill back formula and there's some fees. So that's specifically what we'll be looking at. Section 1 eliminates the Green Mountain Care Board's duty to review and approve the statewide health information technology plan. So then that plan has been in effect for a number of years and gets updated by the Department of Vermont Health Access. So it stops having that be a duty board and does make the representative of the Green Mountain Care Board who's on the Health Information Exchange Steering Committee a voting member. Currently, there's somebody on there, but they're not a voting member. So lots of deletions of references to the Green Mountain Care Board as kind of the approval authority on the statewide health information technology plan. Section 2 eliminates, again, some more references to the board approving the HIT plan, but also eliminates the duty of the Green Mountain Care Board to approve Vitals budget, the Vermont Information Technology Leaders. There were some significant financial issues with that entity for a number of years, and there's been a lot of work in that area. And so the consensus was that was no longer necessary. Section 3 is the bill back provision. So the Green Mountain Care Board is authorized under statute to bill back the regulated entities for a portion of the cost of regulating them. You'll see in a moment what those regulated entities are. And so the bill back formula is a 40-60 split, 40% of the board's expenses, except those that are directly billed based on other.
Under current law.
Current law.
Okay.
Yep. So keeping this 40% by the state, 60% is industry. Under current law, that's broken out between hospitals. This whole list in here is just a description of the different types of health insurance companies. So currently 28.8% by hospitals, 23.2% by insurers, and 8% by accountable care organizations. As many of you probably know, the big accountable care organization, One Care Vermont, is winding down its business and will be done by the end of this year. So there will no longer really be at least that accountable care organization that was required a lot of effort to regulate. And so most of the funding for the ACO came through the hospitals. So most of that 8% is going into the hospital's percentage here and a little bit in the insurers. So then we still keep the 40-60, but going forward, it would be 36% hospitals, 24% insurers for bill back. Okay, keep going. Section 4 has some conforming changes reflecting the changes that were made to having, this is the board's duties. So the board would no longer have that duty to review and approve the statewide health information technology plan or to review and approve the criteria required for healthcare providers and facilities to create or maintain connectivity to the health information exchange. So that has already happened and been in place for a long time. And the board, I believe, does not feel it has the right expertise in that area anyway. Also taking out the review and approval of Vitals budget. And then number 12 is repealing some language requiring the board to review certain data reported to the Department of Financial Regulation and in a technical advisory group. These underlying statutes have been repealed or amended. So there is no, this is just an obsolete provision. So it's making a conforming change to repeal that. Section 5 is oversight of accountable care organizations. So there's some pretty significant changes happening here in order to both reflect that we likely will not have a big Medicaid and or commercial insurance participating accountable care organization going forward, or at least in the foreseeable future. But there are a number of Medicare only accountable care organizations that already operate or are planning to operate in the state, and there's interest in having board oversight of those, but not to such a significant extent as they had for the One Care type. So this is streamlining some of the certification process for accountable care organizations. The House Health Care Amendment and the first instance of it, or second instance, changes the effective dates. So this would take effect in 2027. I believe is what it was when section 1 will take effect, and then the budget review piece takes effect in 2026. Am I getting that right? Junior numbers, great. So a lot of changes to the scope of this subsection A here is all about the certification, and so what criteria have to be met in order for what going forward will likely only be Medicare only ACOs, although it applies to any ACO, and to operate in Vermont. So I don't know that you want to go through the specifics, but just understanding a bunch of changes there. Also allowing the board to adopt rules, notwithstanding even what's in there, to establish a more streamlined process for certification as a Medicare only ACO for an entity authorized by the federal government to act as an ACO under the Medicare program. And it may require that the ACO meet only one or more of the criteria set forth in subdivision 1. And again, that would only relate to Medicare beneficiaries and as allowed under federal law. Subsection B is the Green Mountain Care Board's budget review for ACOs. And again, this is making some fairly major changes, making it specific to ACOs that receive payments from Medicare or commercial insurers or both. So this is,
Medicaid, did you mean?
I meant Medicaid.
Okay, great. Okay.
Even I got it wrong. Yes, Medicaid or commercial insurers or both. And so this is if we did have another OneCare type, larger ACO model in Vermont. So the scope of some of this information is different as well as far as what would be required for budget review, but it's not, I believe, anticipated that this will occur in the near future. We're not aware of any planning to begin operations, and we don't have any programs for them to participate in. Finally, in here we have the fees. This is where you come in. So the board would collect the following amounts from an ACO: $10,000 for initial certification and an annual $2,000 maintenance of certification or renewal of certification. So that's for subsection A. That's where we're expecting these Medicare only ACOs to become certified. And then $125,000 for each review of an ACO's budget. So if there was a Medicaid or commercial insurance or both ACO in the future, then that would be the cost for ACO budget review. Section 6 makes some timing, sort of technical timing changes around the hospital fiscal year to reflect that when psychiatric hospitals not operated by the state, which is really Brattleboro Retreat, came under Green Mountain Care Board budget review, hospital budget review a few years ago. There wasn't recognition of the fact that they run a different fiscal year than the rest of the hospitals. So this is reflecting that most hospitals, so general hospitals, have a fiscal year that runs on the federal fiscal year, October through September, but the retreat uses a calendar year fiscal year. So that authorizes what's been happening. Section 7 is on hospital budget review generally. Again, aligning those dates with the preferred fiscal year of the different entities. The House Healthcare Amendment, the first instance of amendment, makes some changes in section 7 as well to specify that an enforcement of the Green Mountain Care Board budget order for a hospital should not be construed to be a contested case and uses the same appeals process to the Vermont Supreme Court as the rest of the board's regulatory work. Section 8, and we can look at those amendments as well. Section 8 has to do with the meetings of an accountable care organization's governing body, and this is limiting the existing broad provisions around how that has to work and the openness to the public participation is specific to an organization that contracts with Vermont Medicaid. So we would not have anybody falling under this section in the foreseeable future. Section 9 repeals the Medicaid advisory rate case. Had the Green Mountain Care Board for a time looking at the rate case, I believe, as it was paid to the ACO. So this is not particularly relevant. Section 10 is the effective dates, which change a little bit in the House Healthcare Amendment. So I can show you that. Do you want anything you want me to talk about in this document before we look at that one?
I'm just not sure if it's amended, so I'm not sure.
Okay, so the amendment first. Thank you.
Okay. So The amendment just goes into sections 7 and 10. Section 7 is the hospital budget review. So as I mentioned, it would specify that notwithstanding any part of the Administrative Procedures Act, which includes the contested case provisions, the board's review, establishment, and enforcement of hospital budgets under this section shall not be construed to be a contested case. It's my understanding it's really codifying what has been the board's practice, particularly around enforcement, which is the piece that has recently come under question. And any person aggrieved by a final board action order or determination under this section may appeal as set forth in the board's standard appeal statute, which is an appeal to the Vermont, which is exhausting administrative appeals at the board and then appealing to the Vermont Supreme.
Representative Maslin.
Yeah, thank you. And as I understanding, taking contested case off the table essentially just simplifies the process unless there's an appeal. And it makes it much more straightforward. Correct? Or am I-
This is just for enforcement of a budget order.
Yeah.
My understanding is in the past, the board has not used the contested case process. They did not believe it was either necessary or applicable. There's currently litigation about whether they should be using a contested case process for budget enforcements because of some ambiguities in the language. We'll see it get struck later. So this would clarify that this is not a contested case. So there is the process. It's just a different process.
Contested cases, sides are drawn. People follow the back and forth.
Right. It's
Just completely unnecessary.
a longer, it's a more extensive process.
Thank you, ma'am.
So then it makes the changes in the dates that we saw in the bill as it came over from the Senate. So these are still the hospital budget year dates were modified, and then strikes the language here in the enforcement provision that allows hospitals to appeal any decision to Superior Court and has appeal on the record. This is actually a quite outdated reference to when hospital budget reviews used to be done in BISHCA, now the Department of Financial Regulation. And so it actually provides a standard of review tied to the commissioner of DFR, which doesn't really make a lot of sense here anyway. So it would strike that in favor of specifying the standard appeals process for board orders. And then the second instance is changing the effective dates. So in section 5, which is the ACO certification and budget review, subsection A, those changes to the certification take effect on January 1st, 2027, and the rest of it would take effect on January 1st, 2026. So the budgets and everything else. And then the other pieces are the same as came over from the Senate, the hospital budget review timing and appeals process provisions would take effect on passage. Everything else takes effect July 1st. Charlie, do you have a question?
Yeah, wait for up to no one.
Okay. Representative Maslin, do you have a question?
I thought you might be ready for motion.
I'm not. I hear this one out. Thank you, though. Okay,
My hand before.
thank you. No one has any questions for Jen Carter. Thank you very much. And it is a true art to take us through a bill quickly and thoroughly, and I appreciate how well you do it.
Okay.
Thank you. Hi, Eric. Thanks.
Oh. First time using it up here. Yeah. For the record, Nolan Langwell, the Joint Fiscal Office. I am here to talk about section 3, section 5. I feel like with section 3, you have heard this testimony already because this is the same language that's in the budget. So when you saw the budget testimony, this is exactly the same. It came in both places. I can talk about it again, or we can move to the next session. It's up to your point. How much time do you have?
I see no one requesting more words from you, so let's move on.
I take that personally.
No.
Maybe.
So section 5, this establishes fees to be collected from an ACO by the Green Mountain Care Board for its regulatory activities. There would fees for be $10,000 for the initial certification, $2,000 annually following the initial certification to the main certification, and then $125,000 for each review of the ACO's budget. Now, many of you have been hearing how OneCare is going out of business, but there are actually 3 Medicare-only ACOs as well in the state. So these ACOs that participate, these are ACOs that only participate in the Medicare program and have Vermont providers in their network. So they might not necessarily be housed in Vermont, but they have Vermont providers. There's also another Medicare-only ACO that would like to operate in Vermont in 2026. As such, it is anticipated that the board would collect $40,000 in fees from ACOs in fiscal year 26, and then approximately $8,000 in subsequent years. The Green Mountain Care Board does not anticipate any ACOs requiring a budget review in fiscal year 2026, which has a proposed fee of $125,000 in this bill.
No, can you tell, what are the 3 ACOs that are operating now?
May I phone a friend?
Yeah, that sounds.
You may, yeah.
It's better.
Oh.
Because I don't know the answer to that. We could also get back to you.
That'd be great, thank you.
Okay.
Thank you.
The fees, $125,000 for each review of an ACO's budget. This is proposed for any new Medicaid ACO,
Well, any ACO.
any ACO. So the one that's proposing to.
Okay.
Medicaid or commercial. Okay, so the one that's proposing to come into Vermont as a 4th is just Medicare, and that would not be subject to this, but these fees?
I'm looking at Jen.
Jen Kirby, legislative counsel. I believe that is correct. The language, go back to the language, but the language that modifies the budget process, is specific to, yes, is specific to reviewing, modifying, and approving the budgets of ACOs that receive payments from Medicaid or commercial insurers or both.
Okay. Thank you. I guess I'm just looking at these fees thinking that's essentially eventually paid by the people receiving the treatment. So it just seems like a large, could you tell me, is this to recover costs, generate money, or change behavior?
I'm gonna phone a friend if that's okay. Sorry. Because these are fees that were, the Green Mountain Care Board proposed these fees. So I would prefer that they justify why they're so high rather than explain why they're doing it. That's okay.
Does anyone have any other questions for Nolan?
No.
Okay, thank you, Nolan. Would you like to join us in the chair and Nolan can exit the chair? Thank you.
I'd be happy to.
I would love that. Thank you.
Thank you. My name is Jean Stetter of the Green Mountain Care Board. I am the Administrative Services Director, which includes budgets and financials.
Thank you for joining us in Ways and Means. I don't think you've ever been here before. We're happy to have you.
Delighted to be here and join you. So, a few things. First, the Medicare only ACOs. The reason why we don't have a budget review for them is that they generally operate in a number of states. They are generally not domiciled in Vermont, and they offer products in a number of states. So and because they're Medicare only, they've already been approved by the feds for the services they offer. So what the Green Mountain Care Board would like to do is we're taking it currently, we're striking our current ACO statute bill back because it's no longer appropriate given OneCare's exit from the market. That leaves us with zero bill back from accountable care organizations. For the benefit of Vermonters, we do want to do the initial certification and subsequent review of Medicare-only ACOs that will be operating in Vermont. Because of the previous, like I was just saying, because of the previous review that those entities have had to go through with the feds for Medicare, we don't feel like the budget review is necessary. And so that's why we propose those fees. If this does not get passed, we will be doing the work without getting fees. And that will be paid for by Vermonters. The Medicare-only ACOs are generally not domiciled in Vermont, so any fees paid by them will reduce the amount that Vermonters, insurers, hospitals have to pay. When calculating these fees, we looked at the hours of work required for each initial. And generally, I know that historically, the fee bill has been on a 3-year cycle. So I really tried to look at it in like a 3-year cost window. I know the fee bill has not come up every year, but that was my base assumption from my training back when I worked in finance and management. The budget review is, the legislature determined that it was necessary for the Accountable Care Organization. There was an entity operating in Vermont for Medicaid and commercial. So we were comfortable not doing that because the feds had done the review to make sure that they were operating appropriately. For an ACO that is serving Medicaid and or commercial, we believe it's important for Vermonters to know, to do a budget review, to know that that ACO is operating in a manner that is what we wish for Vermonters. It takes a material amount of time, which is why you see that very large number. So it is developed based on hours. We have historical information from regulating One Care Vermont. We've seen process and other improvements. And so that is where it was determined from. And again, I looked at like assuming a 3-year fee bill cycle.
Okay, thank you very much for that. Covering your costs. I mean, you've done a job.
Yes.
Figuring what those costs are. Okay, thank you.
Exactly.
Very helpful.
And because we're 40-60, the reason why this is particularly important is if this doesn't pass, it just means we're doing the ACO work and that cost is being borne by other entities.
Thank you.
All
Thank you
right,
very much for joining us.
thank you.
Really appreciate it.
Thank you. I appreciate your time.
Saoirse, you have the name for the agenda? Okay, great. Thank you. No, thanks. Are you the reporter?
Yes, I am.
What's the vote out of your committee?
8-3 acres.
Thank you. And your name for the record?
Wendy Critchlow.
Thank you. Okay. Any further questions anyone needs answered? Yes. Not you.
Maybe isn't, key to our piece of it, and the information for me. That amended section 7, did that clean up any, my understanding is the Vermont Association of Hospitals and Health Systems did not approve of that, is that correct?
I think that's a question for you, Representative Critchlow.
Okay, say it again, I'm sorry.
So I've got a note here that says that the Vermont Association of Hospitals and Health Systems did not approve of section 7. Is that the amended section or the original section or both?
Let's see, that was one with the. If that's the case, they didn't like it.
Right. All right, thank you.
Absolutely. And Representative Maslin, I think a while ago you asked if I wanted a motion on this.
Sure.
Great.
Would you like a motion?
I would so much, thank you.
Move that the committee approve the,
S63.
as presented, as amended, as, you know, as we have.
Representative Maslin moves that the committee find favorable S63 as voted out of the Committee on Healthcare.
Right, thank you.
Absolutely. Any discussion? Seeing none, if the clerk can please call the roll.
Representative Brannigan. Yes. I'll vote yes as Representative Burkhart, Representative Feltus,
Yes.
Representative Higley,
No.
Representative Holcomb,
Yes.
Representative Kimball,
Yes.
Representative Maslin.
Yep.
Representative Odie,
Yes.
Representative Wazazak,
Yes.
Representative Canfield,
No.
and Representative Kornheiser.
Yes.
We have voted favorable, S63 as amended by the Committee on Healthcare, 9-2.
Thank you. Representative Brannigan, can you report that?
Yes.
You just voted yes, right?
Yes.
I might have gotten distracted in the middle. Okay, thank you. Great, thank you. Appreciate it.
You'd like me to report the bill?
Yes, please. Yes. Thank you. And Mike, for the record, what are the ACOs? Oh, now you close that window? Sorry.
I've got it right here.
Okay, thank you.
So, sorry, it was Mike who helped me, so I'm gonna give you the props. Vitalized Health, Gore Health, Aledade, Accountable Care 205.
Never heard of those. Thanks.
Could you say those again?
Yes, actually, can you send an email?
I'll send it.
Great,
sounds
thank you
great.
so much. Appreciate it. Okay. Thank you, everyone, for your prompt work on that. S63, thank you, healthcare folks. Eric, thanks for coming upstairs early, even though we didn't get to you early. Did that too.
Good morning, everybody.
Good morning.
Nice to see you.
Nice to see you.
Thanks for having me today on the Senate the Senate and House Judiciary's annual miscellaneous bill. My understanding is that the committee is looking at the sections involving the marriage license fee. Is that right?
So if you could do a very one sentence per section on the whole bill, since we have to vote on the whole bill, that would be delightful.
It's gonna be lengthy.
Then maybe a quarter of a sentence.
Okay.
Yeah.
Sure. The section 1 was requested by the Attorney General's office and just clarifies language related to the adult court diversion program. Section 2 was requested by the judiciary and was a clarification that although it is implicit, that it explicitly provides that the General Assembly has the power to set the number of Superior Court judges without having to change this statute every time that the number changes, because right now the number 34 is in statute, so it changes over the years, so that sort of thing. Section 3, and Section 4 and 5, all related to clarifying language in the Judicial Bureau that were also requested by the judiciary. Section 6 is a provision that allows, right now, certain types of court case records, those involving the family division and the criminal division, are not available online. This is a leftover from many years ago when the court first started putting records online. And there was concern at the time that providing online access to some of those records wasn't good policy. Now that it's commonplace for attorneys in particular to practice remotely, the idea was to allow those attorneys to practice from their offices and have access to court records in family and criminal cases. So that's that. Section 7, just a stray language deletion that was no longer appropriate given the civil rules on the award of attorney's fees. Sections 8 and 9 relating to switchblade knives strikes the offense possessing a switchblade knife. The reason for that is that switchblade knife is a term that's undefined. And so people who just have common pocket knives that are above a certain length, it turns out might be inadvertently violating the criminal law.
It's been a long time coming, actually. That's something I've been hearing about the whole time.
I know it has been introduced off and on over the years many times. So here it's finally moving along. You're right.
And box cutters now flip out.
Yeah, any of those exactly. Any of those flip knives, common flip knives would, could have been subject to criminal prosecution. Connected with that is Section 9. This is a new policy of the judiciary committees that are trying to do when a crime is repealed, then to try and also provide for automatic expungement of people who had been convicted of the crime back when it was law. The idea being that, well, if it's not going to be a crime going forward, why should somebody still have on their criminal record a criminal offense that the legislature, as a matter of policy, has decided is no longer criminal? Interestingly, on that one, the judiciary was concerned about, well, how big an ask would this be? And they looked back through the last 20 years and there were only like 8 offenses. So not a big deal for them to do the actual expungement, which was nice. Center for Crime Victim Services, which is the same folks that have asked about the fee that we're talking about, also asked for the language you see in subdivision 10, clarifying some of the procedures around compensation, victims compensation board procedures when people are victims of crime. Purely technical language change, section 11. Same with section 12, purely technical language change. Section 13, providing that the same procedure that applies when a guardianship petition is dismissed applies when the petition is withdrawn. Section 14, correcting an error in the, it's sort of a funny one. If you look at page 9, if you guys have the document, this is when the new statutory, or when the Power of Attorney, Uniform Power of Attorney Act was passed a couple of years ago, there's an optional form that's included. The form inadvertently included the same provision twice. So this strikes one of those instances and replaces it. Yeah, that was a nice catch by, actually, interestingly, former Rep. Joseph Andriano, who is a private practice. He emailed me last summer and said, hey, did you notice this? And you might want to fix that. So that was nice. Inserts the language that should have been there in the first place. Interestingly, here's a provision that this committee looked at last year. You may recall, we looked at some trust bills last year. Yep, that's section 15, line over on page 11, correcting a cross-reference was wrong. So cleaning up that. Right. I take responsibility for that one since it was my bill. Section 17, page 11, this is also requested by the Attorney General's office, the diversion office over there, some clarifying language in their governing statute. Section 18 is tough to do one sentence on that one. The idea there is that right now in the land records, there are provisions for situations when real property is sold. When property is sold, a title search generally has to be done. These property records can be lengthy and complicated and quite old. And sometimes there are flaws in some of these records. And so there are provisions in current law for situations where if the record has been there in the land records, if the document has been there for a long time, usually 15 years, sometimes less, and hasn't been challenged legally, then it's validated. It's deemed valid. So in other words, you're not going to have a problem with not being able to certify a clean title if something's been in there for 25 years, for example, something that said it was executed under a power of attorney, but power of attorney didn't have the right number of witnesses, something like that, some technical flaw. But no one ever challenged it, then it's deemed valid. That exists. This adds one more instance to that. And the instance being that if the document says, hey, this is being executed under a power of attorney by somebody else, it's not the seller signing it, it's the seller having designated under a POA somebody else to do it. And it's been there for, I think it's 15 years in this one. Yep, 15 years. And nobody challenges it. We're deeming that one valid as well. So that's the proposal there. That was actually the proposal of the Vermont Bar Association's real property and probate trust law sections. Next section is just correcting the name. Chief Superior Judge, who's now happens to be Judge Zone, that type position used to be called the administrative judge. Tried to catch all the times that we needed to correct that, but we missed one, so that's here. The sections 20 and 21 repeal the Coordinated Justice Reform Advisory Council. That is a council that, from what I understand, both the executive director and the head of the board on that council have asked for this since their primary responsibility of making this particular budget recommendation no longer exists. Sections, actually, you may have it in front of you, but sections 22 and 23 involving public inebriates actually are going to are going to be struck from the bill, the floor amendment. So you don't really need to think about those because they actually have already passed. Yes. And in fact, it's on the way to the governor now in S-36, which the Senate agreed to the House amendments to that. So no need to have it here. Section 24 creates this firearm surrender order compliance working group, request from the Attorney General and Center for Crime Victim Services. The idea here being that there's a number of different places in Vermont law where surrender of firearms is ordered as part of the process. For example, relief from abuse order, extreme risk protection order, domestic violence convictions. This doesn't change any of that, or whatever underlying Vermont law stays the same. But the idea is to try and make a consistent procedure, because right now there isn't one. So that whenever there's a provision of law that requires surrender, this committee, task force will work on developing a consistent procedure. The language, this is section 25, page 20. This is actually reenacting some language that was repealed in the miscellaneous bill last year, which after the family law practitioners, it was requested by DCF originally. Family law practitioners noted that actually it really would be better to still have it. DCF agreed with that, so they're reenacting. Strange old statute that's on the books in section 26, been on the books for many, many decades and has not been enforced. It was just sort of found, I think, by an attorney in private practice recently during the interim, that allows the criminal prosecution of a child who unreasonably failed to provide financial support for their parents.
That was one of my constituents that found that.
Oh, thank you. Right, yes. I knew it can't. Sorry, I didn't remember
That was
that.
fine.
Yes. Yeah, well, here it is, section
Great to
26.
be visiting the State House today.
Really?
Well, thank you. Any-
Yeah, definitely, right. That's serendipitous.
Something this year.
Right.
That provision?
The W child provision, yeah.
Right.
Yeah, because thank you.
Next two sections are the marriage license fee provision. So this is the repeal of the sunset a couple years ago in 2023. What at the time was a $60 fee that is payable to the town clerk when people get married for the license fee, which increased from $60 to $80. The sort of distribution of that fee remained sort of proportionally similar to what it was before. So the town clerk kept $10 before. Now they keep $15 under the new $20 increase. So they keep $5 of the $20 increase, and $15 of the increase goes to the Domestic and Sexual Violence Prevention Fund. So as I say, their proportions are roughly the same as it was when it was 60, but it bumps it up. So this has been in effect for the last couple of years. When it was passed, though, it had a repeal of this year, July 2025. I think the consensus is that the increased fee is working very well and it's important as is, so the repeal the sunset and keep it. Section 29 permits the state to repeal a bail revocation denial. Section 30 and 31 actually primarily section 30 is related to the earned time program administered by the Department of Corrections. That was requested by the House Committee on Corrections and Institutions. So they wanted to increase victims' notification of the earned time when an offender earns it. Section 31, also House Corrections and Institutions, establishing a task force to review all instances in which victims get notice and try and come up with a better automated system of providing notice to victims when they have a right to it. Adult Involuntary Guardianship Working Group, that's section 32. This was put forward by the judiciary and in particular the Probate Judges Association, because the adult guardianship proceedings right now can take place in two different courts, the probate division and the family division, depending on the type of proceeding it is. So they're going to look at, would it be better in terms of efficiency and policy consistency to instead merge them into one proceeding in one court and then report back to the legislature on that. Section 33, I think in 34. This is the capital budget requests by the counties, right? So there's a statute in place that says when a county requests a capital budget increase for their courthouse, there's a procedure they have to go through. They have to go through the court administrator, and the court administrator makes a recommendation to BGS. This adds some criteria on the basis of testimony that House Corrections and Institutions heard about. Some counties are better at others at having reserve funds in place for their county courthouses. So they're trying to encourage the use of those, be more funding. And there's a report on it in section 34 on how this new process is going to work. Section 35 is, this has to do with second DUI offenses. So when, under current statute, when someone gets a second DUI offense, in addition to their criminal penalty, they have to do either 80 hours of community service or 60 consecutive hours. This decreases that, sorry, they have to do 200 currently. They're bumping that down to 80 as a minimum because they're hoping that people will start utilizing the community service option more than they are now. And that has a 3-year repeal, section 36. So that's in effect for 3 years. See how it works. Yeah, I think they're going to see whether it actually does what they want it to do. Family forensic evaluator recommendations. The family forensic evaluators are folks who evaluate in cases involving parental rights, responsibilities, that kind of thing. They do an analysis of family situation. They're having trouble finding people to do that job, and it's very helpful. So they're going to look at maybe finding a way as to why they might get people to do it. Child and parent legal representation. The Chief Justice just testified about this downstairs in House Judiciary. This is a task force that the court and the chief are very interested in to try and see if there might be an improvement of the proceedings involving representation of minors in various types of court cases. So that's going to be a task force that reports back as well. And that's pretty much it, other than the effective dates.
That was amazing.
Right, well,
That was like, might win the award for the year, actually. Thank you.
sorry if I was speaking too quickly.
It's delightful. Apparently people pay more attention to people who speak quite
They do.
quickly.
Really? That's what we've heard.
That's what we've heard, not from a witness.
All right. Oh.
Does anyone have any questions for Eric? And as, I don't know if folks noticed, it was unanimous coming out of the Judiciary Committee.
Great.
Thank you, Eric.
Yes, happy to help.
That was great.
Any other questions, let me know.
Well, thank you.
Yep.
Yes. Do you want to tell us about the judiciary, the fees? Will you tell us about domestic violence?
Joint fiscal, Madam Chair, I heard you indicate yesterday that you were hoping to hear this in 15 seconds or less. So you all will remember the marriage license fees, which continue to be reflected in the budget because the BAA was folded into the budget. You'll see that in section 27 and 28 as well. Same. Any questions?
No questions. Thank you, Chris. Can someone please make a motion on S109?
Make a motion to find S109 favorable.
Thank you very much. Representative Wozniak moves that we find S109 favorable. Any discussion? Yes,
So that means that there's no hope to change that fee, that marriage fee. You're just
it
going.
is in the budget. I think there's, might you be signing the budget today?
Okay.
Okay. Any further discussion? Yes,
I mean, my kids can't help me survive at the end of my,
they absolutely can, sir. They're just not going to,
be made to.
they will not be criminally prosecuted if they don't. Anyone else? Seeing no further discussion, the clerk would please call the roll. Thank you.
Representative Brannigan.
I'm getting too old to do this. Yes.
I'll vote yes. It's Representative Burkhart. Representative Feltus.
Yes.
Representative Higley.
Yes.
Representative Fulton.
Yes.
Representative Kimball.
Yes.
Representative Maslin.
Yep.
Representative Odie.
Yes.
Representative Wazazak.
Yeah.
Representative Campion.
Yes.
Representative Kornheiser.
Yes.
We have voted the bill favorable 11-0.
Thank you. Anyone want to report this? Okay, thanks. And if you could send the email before you go to lunch, it can get moved along. Sure. When we get to the floor at 1. Oh, there you are. Good. Hi. Will you come join us, Ellen? Thanks, judiciary team.
Thank you, everybody. See you next time.
It was a pleasure. Hi, we have 2 whiteboards and it wasn't for the judicial. And it was not for the judiciary. But it is, because we're working on S-127. And we would love if you could tell us just a little bit about 1A, 1B, and 2, and what the status of those are.
Sure. Ellen Tchaikovsky, Office of Legislative Counsel. So you recall that last year in Act 181, you revamped the thresholds for what Act 250, where Act 250 jurisdiction will apply, based on the physical traits of the site. And so work is underway currently to create what we're calling the tiers. Tier 1, which has Tier 1A and Tier 1B, Tier 2, and Tier 3. And so I like to start with Tier 3 and work my way backwards to define them. So Tier 3 is critical natural resource areas. And those are going to be defined by rules that the new board is adopting. They're currently having a public hearing process to determine which areas will fall into this, but it includes, they're supposed to look at wetlands, alluvial erosion areas, the river corridors, headwater streams, steep slopes. So they have a defined list of things they're supposed to look at, but determine if those things are critical and need to have additional Act 250 jurisdiction. Tier 2 is defined as anywhere that is not Tier 1 or Tier 3. So Tier 3 will be these critical natural resource areas. Tier 1 are developed areas where the municipalities have worked to decide they want to encourage development. That has been split into Tier 1A and Tier 1B. Tier 1A designation requires the municipality to apply to the Land Use Review Board for an area of the town that has municipal bylaws that correlate to the Act 250 criteria, and they are listed in the statute. They also have to have infrastructure and adequate staff to do the actual review of projects in that area, because Tier 1A is creating areas that are exempt from Act 250 by having the municipality then do that review at the local level with their municipal permitting. And so there has to be a municipal bylaw permitting system where the municipality is doing review. So if a town applies and is granted Tier 1A area status, that area of the municipality is exempt from Act 250 review. The areas roughly correlate to what were previously the designated areas under our designation program. So we have an existing program that has downtowns, village centers, new town centers, which are the traditional core of a municipality with mixed uses, including commercial, residential, and sort of civic uses. And so the way these areas are going to be identified is that currently the regional planning commissions are all directed to update their regional plans and their maps using consistent terms. They will do that by working with the municipalities to identify what are the areas within their town that fall into the different categories, including these downtown or village areas. Along with the planned growth areas within a municipality, those areas will be eligible for Tier 1A. Tier 1B has a slightly different approval process. Tier 1B, the municipality will work with the regional planning commission and ask that certain areas be designated as Tier 1B. Those areas will have an exemption for housing in those areas. And so the areas that are adjacent to the downtown or whatever the core is, and those are identified on the maps as village areas. And so they're like, I think what we considered them previously was the neighborhood development areas or the neighborhoods. So the areas slightly outside the downtowns. There are less requirements to be designated as a Tier 1B because it's not a full Act 250 exemption. It's just an exemption for up to 50 units of housing per project. So these areas, previously under they roughly correlate to areas that were designated under the previous program. There were 23 downtowns. There were 23 downtowns. There were 3 new town centers, and there were more than 210 village centers. Not all the village centers will qualify because not all of them have zoning. And so if towns want them to qualify, they will need to have the zoning requirements that are in the statute. And then there was also 5 neighborhood development areas and 7 growth areas. The requirements to have one of those designated areas are different from what is required for Tier 1A. And so just because there were those 200 and something existing designations does not mean the towns that don't have them will not be able to apply for Tier 1A. They have to meet the Tier 1A requirements, which are primarily around the zoning that's in that area of the town. Tier 2 is everything else.
Okay, Tier 2 is everything else.
Everything else that hasn't been designated a critical natural resource or one of these core areas under Tier 1A or Tier 1B.
Okay. You spoke in the future tense.
Mm-hmm.
Can you add more
Sure.
dates to the future tense?
Yeah, so the regional plan maps
I
are
asked that question.
already required, they are required to be finished by December 31st of 2026. And so once.
Can you say that one more time? There was
Yes, the regional plan commissions are working on their plans and maps, and those have to be finished by December 31st of 2026. That work is already underway. When the Regional Planning Commission finishes their map, they will submit it to the Land Use Review Board, the LURB. That process will start designated the Tier 1Bs because that's part of that approval process with the regional plan maps. And then towns may begin applying for the Tier 1A. So I don't think any of the regional planning commissions have finished yet, though a few of them are close. All of them have indicated they will be done by the end of next year with having their maps so that the towns can start applying for their Tier 1As. I don't think they know how long it's going to take because it's unclear how many towns are going to actually be applying, but I do think it will start happening in 2026 into 2027. And then thereafter, towns will be applying for that.
Did everyone catch those dates?
Yeah.
Cool.
Of these different criteria, how many have to, housing project has to be within a half mile of that designated downtown village center?
What do you mean? So, I don't understand.
Well, that was part of our discussion earlier.
Oh, okay.
And it seems like some of them, they have to be within a half mile of the designated area.
Oh, okay. So the first part of what you are looking at are the tiers. The other component that you're looking at for the criteria is the existing interim exemption. And so as part of this update, the legislature also included that exemptions until 2027 in certain areas for housing. And so each of the existing designated areas has an amount of housing that is exempt within them until 2027. And so, yes, for downtowns, let me make sure I'm getting this right. Sorry. Okay, so for a new town center, a growth center, or neighborhood development area that has public sewer or water, they can construct up to 75 units of housing to be exempt. And there's no, it's just the boundary of that designated area. For village centers, up to 50 units of housing can be exempt if it's within a designated village center and 1/4 mile around the village center.
And so Ellen, over the last few years, we've taken a bajillion moments of testimony about a fried egg and the white of the egg.
Yes.
In the neighborhood development area. Is that what we're talking about here?
Not quite. Well,
Right.
we're mixing them. Yes, last year you got beyond it a little bit. And so, yes, within this scheme, it was the fried egg, because it was the cores are the downtowns, new towns, and village centers, and that's the yolk. And then neighborhood development areas and growth centers were the white. But with village center, you're actually adding, under this interim exemption program, you're adding this other additional 1/4 mile around the boundary. So with perhaps
Like where the butter browns on the.
it might be within the yolk, actually.
Runs.
Okay, okay, thank you.
And so it's a slightly, this is an unusual metric that we haven't used before. It's the village center that has zoning and with 1/4 mile around.
When do the interim exemptions end?
Either January 1 or July 1 of 2027.
Okay. So I think that's an interesting thing in the context of this bill, because we're duplicating some of these interim exemptions into 127, but likely the bulk of development and approvals are going to be after these interim exemptions disappear. And we're hanging out with actual maps and tiers. So that's a funny little transition we're going to have to reckon with. Does that match up with your, I don't know how involved we're in 127.
I have not been that involved,
Right.
just the.
Just the brownfield
explaining.
part.
No,
Okay.
just the location part of CHIP is the
Okay.
only part I have been involved in.
Cool. Representative Higley.
So I'm looking at the Act 250 webpage, and it says that on February 15th, 2026, the tier 2 mandates or study will come out. Am I right in that, or?
So that's something else. So the legislature asked the LURB to report back on a number of issues regarding this scheme. And so in 2026, you asked them to report back on if they think changes to tier 2 are needed. Because basically tier 2 is everything else. And so the question is, well, should that be more defined?
Okay, so, but we'll still have that report in February.
Yeah. Yeah.
Thank you.
So the definition of tier 1, the boundaries will not be drawn necessarily until the end of 2026.
Potentially, yeah.
And municipalities have to apply for tier 1A status. And that the approval could be after that date. Will have to be after that date.
Yeah.
So in 1B, what's the timeline on that then? Is it the same?
It's earlier because the tier 1B application is made as part of the regional plan and plan map. And so as soon as the regional plan is done, they submit it to the LURB. That has to be done by the end of 2026. So that will start happening in the near future. So in the next year and a half. Tier 1Bs will be identified and designated.
Okay.
Yeah.
So if somebody wanted to do a development now and not wait until that long, it's just going to be the existing regulatory process that applies.
With they have the interim exemptions.
Just the interim exemption, okay.
Yes.
Yeah.
Yes.
And if they don't get an exemption, that's just go through the Act 250 process.
Right. I mean, I think the idea is that the interim exemptions are within areas that are already designated and that correlate to where tier 1 areas will be.
Okay.
Yeah.
Representative Feltes.
So the language in 127 that we're looking at says tier 1A or 1B or an existing settlement or an area with 1/2 mile of an existing settlement.
Yeah.
So what's an existing settlement?
Yeah. So that's another. Yep, there's a definition that is also an Act 250 definition. It has 2 prongs. The first is either a designated area, so those 5 areas, or
The 5 areas under previous law.
yes.
Okay.
So either a designated area or, and I wanted to have this open before I got here. Or
So 16.
16, yes, okay. Or an existing center that is compact in form and size, that contains a mixture of uses that include a substantial residential component and that are within walking distance of each other, and that has significantly higher densities than densities that occur outside the center, and that is typically served by municipal infrastructure such as water, wastewater, sidewalks, paths, transit, parking areas, and public parks or greens. Strip development is not part of an existing settlement.
But it's typically, not absolutely.
For the infrastructure?
Yes.
Yeah.
Okay.
So,
And so-
last sentence in strip development is
Not included.
typically or it's not.
Not include strip develop. So the way that this has been used in Act 250 for a number of years is looking at the strip development criterion to determine if something qualifies as strip development. It means it's outside of an existing settlement. And so I was just looking up before I got here, there is some case law around this. I did not find that they actually said these are portions of municipalities. They can spill into an adjacent municipality, but they primarily, the district commissions have looked at whether or not there is a mixture of residential, commercial, and civic uses within a walkable area. And so this is sort of one of the catch-all categories if a town doesn't have a designated area, but they have a core that has walkable.
And who determines that something is that?
So currently it's just used for Act 250 and the district commission has, and then the courts have weighed in on a little bit. VEPSI would be making that decision here.
Wow, okay. I don't think VEPSI has the expertise right now to do that, but that's something for us to tackle. Okay. Thank you, Ellen.
Yes.
Thanks, everyone. Let's have lunch.
All right.